In this video, I'm going to describe the two main ways that an agent associated with a corporation can be found criminally liable. And by agent, I mean an individual associated with a corporation. So this can include a director, an officer, oftentimes a senior employee, or a contractor or an agent of the corporation. So there's two ways in which that can happen. I first want to talk about primary liability. This is a way in which the agent is directly and personally responsible for the crimes that are alleged to have been committed. This often comes up in environmental statutes where the definition of the crime is that you, for example, possessed, controlled, or directed a substance before it was released. In that way, it's not just the corporation that commits the crime, the person who has direction, control, or possession of the substance also can be liable for that crime. This situation often comes up with owner-operated corporations that are tightly controlled or tightly operated with one or two people. In those circumstances, not only is the corporation releasing a substance into the environment, but the individual who may have actually physically possessed that substance can be found liable as well. This situation can also include aiding or abetting or counseling the offense. It's quite rare in the case law to find those ways in which the crime can be committed, but they can exist. It's theoretically possible, and you should be aware of it. The second method that I want to talk about today is secondary liability. Most regulatory statutes contain a provision that allows certain individuals to be found guilty of a crime that are committed by their underlying corporation. It requires the Crown to prove three things. One, that the corporation committed the offense. Two, that you're in the class of individuals who might be found secondarily liable for those offenses. And three, there's some form of connection between you and the corporation. In short, and important for corporate counsel when you're working with your officers and directors is it allows directors and officers and senior employees who may not have been involved in the execution of acts that led to an offense, but because they had a decision-making role, they are also found guilty of those offenses as well. Talk about three ways in which one can be found secondary liable. I do want to make sure I distinguish this from vicarious liability. Vicarious liability occurs when an agent or employee commits an offense while in the course of employment with the corporation. That's vicarious liability. The liability flows from the individual to the corporation, and the corporation is automatically, as a matter of law, liable for the offense. Even if no one else in the corporation was involved, the corporation is liable for the offense committed by the individual. Secondary liability is the other way around, where the corporation commits the offense, whether through other employees or other agents or other contractors, but the director and officer who might have controlled the circumstances or aware of the circumstances is found guilty of the corporation's offenses. I talked about the three ways in which secondary liability can be proven. The first one is that the Crown has to prove that the corporation is culpable of the offense. If the corporation is not guilty, then by definition, neither is the individual. However, it is possible for the Crown to charge the individual without charging the corporation. So you need to be careful about that. It also means, though, that as defense counsel, if I'm asked to defend a person charged under a secondary liability provision, then I'm going to argue that the corporation is also not guilty, in addition to the other defenses available to me when defending the individual. The second part of the test is usually uncontroversial, but it is an element the Crown must technically prove, and that is you need to be within the class of individuals that are covered by the secondary liability provision. Wording across provinces and across statutes differ, but they usually include directors, officers, employees, contractors, and agents. If you're in the class of those individuals within the definition of the statutes, then you might be covered by a secondary liability provision. In practice, what the Crown is going after in most cases is what we often call the, quote, directing mind of corporation. And that's who they're going after under these types of provisions. The final part of the test that the Crown has to prove is the connection between the individual and the corporation who's alleged to have committed the crime. And this usually, again, changes depending on the statute, but most statutes will contain 3 out of the following 4 definitions. They'll have direct, permit, authorize, or acquiesce. Direct kind of speaks for itself. You're an individual like a CEO who's giving direct orders for a corporation to do something that results in a crime. Authorize can often mean someone coming to you with a proposed course of action, and even though you might not be conceiving of that action yourself, you're authorizing someone else to proceed with a course of action that leads to an offense. I do want to focus on the concept of acquiescence because it's the most controversial. It's the broadest way in which one can be found to be secondarily liable. Acquiescence usually refers to knowledge or awareness of circumstances that might lead to an offense, but choosing to do nothing about it. It's controversial because the country seems to be split in various provinces about how to address this problem. In some provinces, notably British Columbia, the courts seem to be starting on a path where awareness of risks alone might cause a person to be acquiescing to risks that might lead a corporation to commit an offense. Other provinces are more clear in that it needs to be knowledge of circumstances where an offense is being committed and it's an ongoing offense, and the director or officer or employee is choosing to do nothing about it. At Ascending Law, we actually believe the latter is the better view because risk is more a concept about due diligence. If you're aware of a risk of an offense being committed or that could be committed, then you engage in due diligence to mitigate that risk. Whereas acquiescence is better thought of knowledge of an ongoing circumstance, like if you're a director and officer and you know that oil is being poured into a pond and you choose to do nothing about it, that is acquiescence. But business always encapsulates risk. And so it's tough to mitigate every single unreasonable or reasonable risk. And that's why we think that acquiescence is better seen as knowledge of ongoing circumstances constituting offense. My caution, however, is that this is controversial. It's not clear to us at Ascending Law that every province will follow this. This requires appellate resolution. A great illustration of acquiescence is the decision out of BC called A&A Foods. In this case, a cheese company was charged with handling unlabeled cheese. The director was also charged under secondary liability provision. In that trial, the evidence was that a subordinate told the director, "Hey boss, we have unlabeled cheese in the warehouse," and this director chose to do nothing about it. In that case, it was clearly acquiescence because he was told not just that there was a risk of unlabeled cheese in the warehouse, but that there was actually unlabeled cheese in that warehouse. And so when the inspector came and found out that the director knew about that circumstance and chose to do nothing about it, that is what engendered the culpability of that director under the secondary liability provisions. So in conclusion, we've gone over the two basic ways in which individuals associated with the corporation can be found liable for the offense of the corporation: primary liability and secondary liability. We've focused on secondary liability because it's the way in which most directors and officers and senior employees of a large corporation is found guilty. We've talked about acquiescence in particular because it's the broadest and most risky way in which a director or officer or a senior employee can be found guilty for the offenses of a corporation. In our following presentations, we're going to go over how to conduct yourself and how to counsel your corporation and your directors and officers and senior employees to conduct themselves in an investigation of a potential regulatory offense. And then we'll also, in our final presentation, go over some ethical issues about trying to counsel both the corporation and those who might be charged under secondary liability provisions. Thanks very much for listening to me, watching this video. Visit our website to get more information and download our paper.